Federal employees, the EEOC is proposing to demand more detail in your complaint before the investigation and to take away your current choice to put the case before an EEOC judge. Here are 5 changes I'm looking at from yesterday's proposal and why they matter. Please share to help get this out. This is helpful key information. First thing you need to know, it's still a proposal. The Commission did not vote to change current deadlines. The EEOC said complaints already being processed would not be affected. Number 1, getting your complaint filed. Today, you generally contact an EEO counselor within 45 days. The proposal would replace mandatory counseling with a written complaint, generally due within 60 days. Those are different requirements, and don't treat this as simply getting 15 extra days. Your complaint would have to meet a new plausibility standard before the investigation. How much detail can you reasonably demand from employees when important facts are sitting in the agency's files? Mediation would still be available, but getting through the front door would change. Number 2, adding claims. You would generally have 21 days after filing to add related claims that existed when you filed. Later incidents would follow different rules. So what happens when you learn about another discriminatory act from records you received months later? Connected claims could get caught in the deadline disputes or forced into separate cases. That means more procedural fights before anyone addresses what happened. Number 3, the judge and the evidence. The agency would ordinarily decide first. You could appeal to the EEOC, but then the Commission would control whether particular issues go to a judge. Limited discovery would still be possible through authorized referrals. You would lose your current choice to enter the judge's process. Agencies already have to conduct an impartial investigation. How will the EEOC enforce that when the record is missing evidence? If your case turns on who is telling the truth, how do you get a meaningful chance to test the agency's story? Those are the questions I'm going to press. Number 4, class complaints. The EEOC would stop adjudicating administrative class complaints. Federal court class actions would remain available, subject to the court's requirements. Not so sad about that one. When the same policy harms many employees, losing that administrative class process could matter, though. It's not what I do. Commission at any point needs to account for that. Number 5, attorney's fees. Fees recovery would remain where the law allows it. The proposal would restrict use of fee rate charts and focus on rates for comparable federal EEO administrative work. Not really going to affect a bunch, but maybe some people. Taken together, those changes could affect your ability to get a complaint accepted, develop the evidence, and afford to pursue the case. At the end of the day, a quicker decision is not a better decision if it's not a fair one and the employee cannot get the evidence. That's my concern. Will you do this fairly? We'll press the Commission on its legal authority, the evidence supporting these changes, and the costs that could shift onto employees, as well as Department of Justice and agencies forced into federal court. We are keeping our clients' cases moving, preparing for what comes next, but we'll also be responding publicly and helping you do that next week. Our initial breakdown's at fedlegalhelp.com/EEO breakdown. Which change do you want me to explain further? Please keep private case details out of the comments. You deserve a process that gives you a real chance to prove what happened. That's worth fighting for. Thank you, everybody, for your support. Please take care and have a good day.